Chapter 23, Closing the Real Estate Transaction.
Closing is the final step in the real estate transaction. It's a bit more complicated process than just exchanging the seller's house keys for the buyer's money. The closing process involves a myriad of legal requirements, paperwork, and fees, all aimed at guaranteeing the clean, proper transfer of title from the seller to the buyer. Typically, to help in the closing process, the seller and buyer will agree to use a title company. Now, the title company's agent, you'll meet at the closing table, will make sure that the title to the parcel is free and clear, so the buyer likes that, and then issues a title insurance policy for that property. Now, the title insurance policy protects not only the current owner, but also the lender against any future lawsuits or claims against the property that results from any disputes over the title. So they protect the buyer as well, because if the buyer should suffer a loss as a result of these disputes, the title company will defend it. So the title company's insurance policy is going to protect the current seller, it's going to protect the new buyer, purchaser, and it's going to protect the lender against future lawsuits as to the validity of the title.
The real estate transaction concludes with the closing of the real estate transaction, and at the closing, the major event is the seller is to deliver marketable title and the buyer is to deliver dollars. But there are a lot other issues and a lot of other considerations that go into the actual closing. Those are the two big events. The centerpiece then of the closing of the transaction then is that all the costs and the expenses, monies received, monies to be paid for all the parties that are involved in the transaction are accounted for. This includes monies between the seller and the buyer, money between the buyer and the lender, the title company charges, real estate agents' commissions, and of course attorney's fees. From the buyer's perspective, what are their major issues or their major concerns? The first is going to be that they're going to get good marketable title. And so they're going to need some title evidence. They're going to need some proof that what they in fact are getting is marketable title before they pay their money to the seller. Buyer's also going to be concerned about the deed he's going to get from sellers. A, is it properly prepared? And B, does it have the particular information that he needs on the deed? Is the form of deed the correct deed? Is it a warranty deed, as he requested? And how does it say he's taking title? So those will be a big concern with when the buyer reviews seller's deed for accuracy and for its correct form. The buyer is going to look for any documents that will release any of seller's liens, owner's liens, if any are on record and can be released. He'll ask for documents showing that they in fact have been released to public records. He'll look for a survey, if you will, a picture of the parcel itself. The big interesting thing that he's going to be looking for with the survey is to see if there's any easements or any encroachments, either his property encroaching on somebody else's or somebody else's property encroaching on his. So he'll ask the seller to give him a recent survey. The buyer is going to look for inspection results. If he had, for instance, environmental inspections, or if there was some mitigation that had to be done, maybe radon or lead-based paint, he'll want to make sure he has the inspection results and all the compliance forms there at closing, so he's sure that they've been remediated. The buyer will probably do a walkthrough before closing, and particularly he's going to be looking for, as he walks through the property, any repairs that the seller had agreed to make. If the property has leases on it, say it's an investment property with a multifamily investment property, The buyer is going to want to make sure that he sees the actual leases. If he hasn't already, which he probably should have got them already, but if he hasn't, he's going to want to see the actual leases and take one final look at them to make sure that they are valid leases, when they're set to expire, and what the rental rates are on those, if that's what, in fact, the seller had disclosed to him, if that's what he sees on the actual leases themselves, so he can justify any income that he's expecting to get on the leases for a multifamily building.
So prior to closing, the buyer and their agent will do a final property inspection. This is where they walk through the property shortly before they actually go to the closing table. And the buyer walks through with their agent and verifies that necessary repairs have been made. These are the ones that were maybe found with the home inspection. Maybe some issues that the buyer wanted taken care of prior to closing. So they're going to do a walkthrough to make sure that those necessary repairs were made. And they want to make sure the property was still well maintained. There's not any other issues out there that have injured the property. All the fixtures are in place, so the all of the shelving units next to that beautiful fireplace are still there and weren't ripped out. And there is no unauthorized removal or alteration of any part of the improvements that has taken place.
What will be the seller's issues? Or what will seller be bringing to waylay the buyer's issues that we just talked about? Well, the seller's going to bring a deed to convey the real property to the purchaser, and the seller's also going to bring a bill of sale to convey any personal property that they agreed to. Seller's going to bring a title policy, which is the usual form of title evidence that sellers here in Illinois bring in any event. And the title insurance policy will, if you will, guarantee or ensure that the purchaser is getting good or marketable title, which is what he requested. The seller will be bringing an affidavit of title, which basically is a piece of paper that says, since the day I ordered title evidence and the title insurance company started investigating title on this parcel, since that time until the very second we're closing here, my affidavit of title ensures to the buyer that I have done nothing to encumber the property or put any other liens on the property that he's not aware of. Of course, we'll get that survey. As we mentioned, the buyer wants to make sure that the property is not encroaching or other parcels aren't encroaching on his property, or a fence that he has isn't encroaching on somebody else's parcel, and see if there's any easements that he should be aware of. And so he'll get that survey from the seller. Again, the seller's going to bring the results of any inspections that he was requested and required to make. He'll bring some actual proof of repairs, actual receipts. It's going to be one thing that the buyer's going to go to the house prior to this through a walkthrough and see that repairs have been made. But now we want to make sure that these repairs were in fact paid for and exactly what was repaired. And then, of course, there'll be paid receipts, water bills, transfer tax stamps. The seller is responsible for buying those transfer tax stamps and, of course, paying the utilities for the day of closing. The big utility is the water bill, because if the water bill isn't paid, you can't get transfer tax stamps. If you can't get transfer tax stamps, you can't record the deed. If you can't do that, there's going to be a problem at closing. And, of course, what we've all been waiting for since Chapter 1 of this book until Chapter 23, what this whole thing has been about is getting licensed so you can pick up that commission check.
And just a word on title insurance policies. Before issuing a title insurance policy, a title company will search the public records. This includes records on deeds, mortgages, divorce decrees, court judgments, tax records, child support orders. And their object is to make sure there are no current outstanding liens against the property or easement rights that might limit an owner's rights to the property, or any encumbrance like zoning laws or restrictive covenants that might be imposed by a homeowners association that might affect the ownership or cloud the title. They make sure there's no lawsuits filed or any judgments against or any rights others may be claiming against the subject property. Now, there are two policies. The owner's policy, which is the title policy that the seller purchases for the buyer, if you will, the two owners. And then there's a lender's policy. If there's a loan involved here, then the buyer who got the loan is also a borrower, and so he's going to need to purchase one to protect the lender. So in the future then, these title policies will continue to protect the buyer, the lender, and even the original owner against lawsuits or fraud brought against the title to the property. So it really is an insurance policy that insures the title and will protect the title in the future and protect those that have had an interest in the title, whether they be original owner, whether they're the current owner, or whether they be the lender.
In Illinois, our closing process is called a face-to-face closing, which simply means everybody sits around the table. They can see each other's faces and they close the real estate deal. Typically, it's at a title company. Sometimes it'll be at attorneys' offices. And we have sitting around a table, face-to-face, the sellers' attorneys, agents are often there, and of course the quarterback of our face-to-face closing would be the title insurance closing officer. The other typical way closings are conducted are what are called closing in escrow. Typically, this isn't found in Illinois. You always hear, if you watch television and they're talking about California real estate sales, they always talk about that they've cleared closing or they've cleared escrow. They close this way in California. Closing in escrow is where we have a disinterested third party, which is basically an escrow officer. And for the sake of argument, the escrow officer would be sort of an agent of both the seller and the buyer. The escrow officer serves as sort of a referee. All documents, starting with the sales contract, are deposited with the escrow officer, and the escrow officer uses that sales contract as sort of a rule book and makes sure all parties have done exactly what they're supposed to do under that sales contract. And then when all parties do that, they notify them and say that their contract and has cleared escrow. So the escrow officer will hold all documents, and then when everyone has done what they're supposed to do, he or she will then send all the documents via mail, or you can pick them up as well, to the parties. But technically, from the time the property has, quote, cleared escrow, title is conveyed.
Your text mentions the Form 1099-S that needs to be completed in most real estate transactions. The 1099-S is also called the Proceeds from a Real Estate Transactions form, and it's a tax document, and this document will ensure that the correct amount of proceeds that the seller receives is reported to the IRS. The document is the responsibility of the buyer. Can't have the seller do it because the seller might lie, obviously, and we don't want them to, give the IRS incorrect information, so we'll have the buyer responsible for submitting it. But typically, it's completed by the closing officer or by a lender if the buyer is borrowing money, or by the borrower's attorney. So it's the buyer that is sort of responsible for providing this form. Now, the information on that form is pretty simple. It simply says who the buyers and sellers are, gives their social security numbers, gives the property address, the date of the sale, and amount of the sale price. The reason for this form is that the sellers need to document as they're selling their property, and they may be buying another one and selling that in the future. So in every transaction this particular seller is involved in, we'll have a chain of these 1099s. So at some point in time, when they want to calculate the capital gains, and therefore any taxes due or maybe not due, they're exempted from, if you will, we'll have a chain of these 1099s to track every seller's real estate transactions. It is important to know that those sellers and the buyers both, when they complete their next 1040 form, they must include this 1099-S form on their tax returns. The other thing that's interesting about this form is that it does require the sellers to disclose whether they are a foreign person, or they're a foreign estate or foreign trust, or they're a non-resident alien.
Now, what exactly is your role at closing as a real estate licensee? Basically, your role at closing is to sit there quietly and collect your commission check, in a nutshell. Be careful when you're sitting at closing that you don't start talking and answering questions to your seller or to your buyer that are starting to encroach on illegal practice of law or practice or encroach onto the title company's responsibilities and the title company representative there. So try to be helpful and courteous, but be careful of the things you say. You're not to be giving any advice or counsel that it could be construed as being legal.
Let's take a look at the transaction and this closing process from the lender's point of view. We have a lender who has lend money to a borrower that they don't know actually on 70% of our real estate transactions. Only about 30% of our real estate transactions are paid all cash. So in 70% of our real estate, commercial as well as residential, real estate transactions, there's a lender involved. So what do the lenders want? Well, the first thing they want is they want their buyers, their borrowers, to get clear title. Because if they get clear title, that protects them. So they don't want their buyer borrowers getting cheated because that may eventually affect their interest in the property, which they don't want. So they're bound and determined to protect their position in this real estate transaction. The other thing they want is that they want to make sure before there's a closing and they give these funds, they fund the transaction. Before closing or at closing, they want to make sure that all the property taxes have been paid and the homeowner's insurance policy is current and has been paid by the seller. They want everything current. Any problems at closing. Then they want to make sure that going forward, their buyer will continue to pay the property taxes as well as keep the property insured. If for some reason the borrower in the future doesn't pay the property taxes or keep them current, or they don't keep adequate insurance on the property, the borrower gave them the right under the mortgage document to foreclose on the property. The lender wants clear title to the buyer because that really protects their interest. So they're going to go even further. They're going to say, buyer borrower, you have to ensure me that the title you're getting is clear title. So I also want a title policy. In case it's not, I can go to the title insurance company and they can pay me off if there's a defect in title. So they make the borrower buy a mortgagee's title policy to protect them. So there's basically two title policies in our real estate transaction. One is the one the seller gives the buyer, the owner's title policy, because the buyer wants to be protected against any defects in title, and the lender, if there is one involved, also wants protection from their borrower to buy them a title policy in case there's a defect in title. So either of them can go to a title company and get paid out if there is a defect in title that the title company insures over. And then the last thing, of course, the lender wants is they want their money back plus interest. And that's the bottom line with all of these documents that the lender is requiring from the borrower, as well as the documents that the lender wants to make sure that the borrower gets from the seller to protect them, the lender.
Now, RESPA, the Real Estate Settlement Procedures Act on 471, really is it's a national act that regulates, if you will, residential closings. This is the way we have uniformity throughout the country in the documents that are to appear at closing. And RESPA does a couple of other things besides giving us some uniformity throughout the country. It helps protect sellers, and particularly buyers and borrowers in a real estate transaction, by making sure everyone knows exactly where the money came from and where it's going to go. So the Real Estate Settlement Procedures Act then is designed to protect consumers primarily against abusive lending practices by requiring certain disclosures. It provides details on all of the costs attributable to the transaction. And we're going to see we do that through a form called the HUD-1 closing statement. Again, RESPA, we're talking about residential closings, not commercial closings. They do not, commercial closings are not affected by RESPA. The other benefit to RESPA is it helps eliminate kickbacks and referral fees between parties. In the old days, sometimes the buyer would be working with their agent and they'd want to know where they should go get their loan. The buyer would say, all of our people get our loans over at XYZ Mortgage Loan Company, or with the seller perhaps they might recommend a certain appraiser or a certain home inspector. And of course, each time that appraiser, home inspector, or loan officer got a referral from a broker, would send them a referral check, attorneys as well. So this is prohibited. And one way we can identify if this is taking place is to make sure that these, if there are any referral fees or kickbacks, that they appear on the closing statement. That way, at least sellers and buyers would be given disclosure of these referral fees. So these are sort of under-the-table referral fees that were going on. And RESPA helps eliminate that so that sellers and buyers are aware of all the costs in the transaction and who's getting paid.
So we see that RESPA was a Consumer Protection Act, and its primary purpose was to make sure there was a fairness in what sellers and buyers were charged in real estate transactions. And some of these charges became outrageous because no one was regulating them. So there were punitive kickbacks between various parties that are offering services in real estate transactions. There were home buyers were sent to certain companies to buy title insurance, and of course, whoever sent them over there got a kickback on it. Lenders were prohibited from charging outrageous escrow accounts or deposits, or taking money to be paid for taxes and insurance and putting those in escrow accounts that charge a large amount of money to hold. So all of these things were going on that when the real estate transaction was over, sellers and buyers slowly got their pockets picked. So essentially, RESPA was there to try to control and regulate the costs involved in real estate transactions, that they're fair for sellers and buyers. Now, after we've just said that, where RESPA prohibits kickbacks of any kind, now we're going to tell you that there is a time when you can get kickbacks and referral fees, if you will. And these are with affiliated business arrangements. Now, this is a very, very complicated area, and all I'm giving you is basically sort of an overview to this. Do not get involved certainly as an owner of a real estate brokerage company or franchise, certainly as a service provider in an ABA, unless it's done legally. So as I say, this is a very, very complicated area, this ABA, and when you may be allowed or permitted to get referral fees in a real estate transactions. So more and more we're seeing that there's a one-stop shopping going on out there, where we'll have real estate brokerage companies, we'll also own a mortgage brokerage company, perhaps a home inspection company, or they'll even refer out to a moving company or to a home inspection company, or maybe even to attorneys or appraisers. And they do that as a group called an affiliated business arrangement. So this is actually a contractual arrangement between these parties. Now, RESPA will permit referral fees from these organizations as long as the customer is clearly informed of the relationship among the service providers, that the consumer does not have to participate in purchasing any of these suggested or referred companies and services. They have to be told that there are other providers available if they want to then go to them and see if they can get cheaper, services from a lender, or cheaper services from a an appraiser, cheaper services from home inspectors, and those types of things. Now, what can this ADA pay the people that are part of the affiliate business arrangement? They can be paid, in this case we'll say a real estate broker, a referral fee, but it must be in direct proportion to the ownership interest in the affiliated business arrangement. So if you're a brokerage company and you have this affiliated business arrangement with these other service providers, and you have a 1% ownership of that, then at the end of the year, when the profits are declared from this ABA, you can only get 1% of the profits. If you own 50% of the ownership in the ADA, you can get up as much as 50% of the ADA profits. So that's not essentially a referral fee, but it is a way that you can profit by making referrals to these other companies that offer services in the real estate transaction. Figure 23.1 shows you a disclosure form that must be signed by whoever the service provider is and whoever the consumer is that you'll be benefiting from this arrangement. So we have these two major consumer protection laws enacted to stop predatory loan practices against borrowers and help ensure borrowers clearly understand the terms and conditions they're getting when they are involved in a real estate transaction. The Truth in Lending Act, again, that truth in lending means that the lenders have to be truthful in their disclosure and advertising of their mortgage terms and mortgage-related expenses. And that's why we have that annual percentage rate, because that annual percentage rate wraps that up into one number that will tell you, where you can go from one lender to another and compare, if you will, the best deal from the lenders that you want to shop using the annual percentage rate. Sometimes I like to call it the true annual percentage rate, because it takes into all the expenses that borrowers are going to incur in a particular loan, not just the loan interest rate. The other major piece of legislation, Consumer Protection Act, is RESPA. And as we talked about, that RESPA is designed to protect borrowers during the loan mortgage process, from getting a loan to the closing. And the two forms that are used primarily with RESPA, so these are the two forms that we talked about that RESPA requires. And I didn't put the forms on there. They're about 7 or 8 pages each. You will see all of these forms in detail in chapter 23 of this book. But basically, when you make a loan application, you're sitting down with the loan officer, they will give you this estimate, this loan application, loan estimate when you make your application to get a loan. They have to give it to you within 3 days of making a loan application. Typically, they give it to you right then. And then you have to get the final closing disclosure form a minimum of 3 days before closing. And what you're supposed to do is basically take that loan estimate and compare it, which is the estimate, the guesstimate, and compare it to the closing disclosure, the final numbers. If these numbers don't gel, or if there's a problem with it, that's your time to call the closing officer and saying, I need an explanation for why these numbers are different. And if they're not unacceptable, then you don't close.
Now, in completing that HUD-1 closing statement that we just saw, there are two things we have to be able to do. One is we have to compute the prorations, and we'll show you how to do that in a second. So coming up with the actual dollar amounts. And then after we get the dollar amounts for our closing statements, we have to determine whether or not we're going to put them in the debit column or the credit column. So our first rule is if you want to take money away from someone, we debit them. And if you want to give them money, we credit them. So each party, buyer, seller, has a debit column and a credit column, and we'll go through each of the prorations. And if this is money that should go to the buyer, we'll credit him. If it should go to the seller, we'll credit him. If it should come from the buyer has to pay it. we'll debit him. And if the seller has to pay it, we'll debit him. So debit takes money away, credit gives the party the money.
So this chart on closing statements gives a good overview to various charges and expenses that occur in most real estate transactions and impact the sellers and the buyers. There are even more than this, but this is at least a good summary of the major ones. If you look down the right column where it says prorated, those are the ones that you do prorations on, and that's where we'll see debits and credits to sellers on these prorated ones. The other ones are simply expenses that are either debited or credited. They're sort of not shared between the parties. So the prorated ones are affecting, those expenses affect both parties. And we're either going to give one of the parties the monies that it applies to and take it away from the other, or vice versa. For instance, if you go to the bottom of the page, we'll see general real estate taxes. Well, in most real estate transactions, the taxes for the given year up to the day of closing have not been paid. So when we do these accruals for property taxes, we'll know that the seller is going to have to pay something at closing for the time he was in the property up to the day of closing, of which he hasn't paid property taxes for, because the property tax bill hasn't been paid yet. So we will therefore compute what the prorated amount of property taxes are. We will debit the seller, take that money away from the seller, and we'll credit that amount to the buyer. So if you go through the prorated expenses here, it'll give you some idea of the major prorated expenses that occur in most real estate transactions. Now pages 455 to 458 give you a list of the more common expenses that are found in most residential real estate transactions. So you're welcome to look through each of those. I think they're pretty much all self-explanatory. Might want to check out some additional fees here that I've added that you won't find in your book, but are also found in most real estate transactions. So you can see where closing can become a very tedious and very complicated process when you get involved in not just all of the different documents that are involved in the real estate transaction, but all the different expenses, and particularly those that have to be prorated between the parties.
Now we learned a little something about the debiting and crediting. Now let's talk about accrued expenses and prepaid expenses. First, let's talk about accrued expenses. Accrued expenses are simply expenses that are debts that are due from usually the seller, sometimes the buyer, but usually they're accrued expenses that the seller owes but has not paid yet. An example of an accrued expense would be current year's property taxes. On our day of closing, let's say it's 2014, on that day of closing, someone has to account for the 2014 property taxes. Now, the 2014 property taxes aren't going to get paid until next year, 2015, which is when they're due. So the seller owes 2014 property taxes due in 2015 from January 1 to that day of closing. So these would be considered an accrued expense, one that is due, in this case by the seller, but has not yet been paid.
Okay, speaking of accrued expenses, an example of one might be property taxes. In this case, we have a closing date as of April 12th, 2025. Now, the property taxes for the year 2024 have been paid, but we have no payment from the seller for his share of the 2025 property taxes. So we need to prorate what the seller is going to have to pay to the buyer for the seller's prorated share of the 2025 property taxes that actually aren't going to be due till 2026. So here's how we solve for it. Now notice that we do have 2025, the period of time prior to closing that seller is in possession of the property. So in 2026, when the property tax bill comes out, our buyer's going to want the seller's share for the time he was in the property in 2025. So we've got to prorate what the seller owes the buyer for that period of January 1 up until the day of closing. Again, notice that our 2024 taxes were already paid, so they're not an issue. So we'll use our $7,200 that we assume our taxes will be the same as they were last year in 2024. So our 2025 taxes are estimated to be the same as they were in 2024 of $7,200. So how do we do it? Well, from January 1 to the day of closing is 102 days. Seller's been in this property for 102 days, so he owes 102 days for his property taxes while he's been in possession. If we take 7,200 and we divide it by 360, that's $20 a day. So seller owes us for 102 days at $20 a day. Seller owes us, the buyer, $2,040 for his share of the 2025 property taxes. And our debit seller simply means that we take it away from the seller when we debit somebody, and when we want to give them money on our closing statement, we credit them. So we take $22,400 at closing away from the seller, debit him, and we give it to the seller, to the buyer on the buyer's statement as a credit. Now we'll talk a little bit about prepaid expenses. Prepaid expenses are when the seller prepays a particular bill into the future, and closing takes place before that his benefit of using that particular item that he prepaid up. So we have to reimburse him for that. An example would be a water bill. Let's say you pay your water bill in advance for each quarter. Here's how this might look. So here's a problem with a prepaid expense. Mr. Stevens sold his home, or is going to sell his home, on November 20th of 2025. That's the day of closing. He prepaid his last water bill, which covered the period of time of October 1 to December 1. He paid that on September 31. So he paid the last quarter from October 1 to December 31. What was the prorated water bill that the buyer now owes back to Mr. Stevens? So here's how we'll calculate our prepaid water bill. And again, the buyer is going to reimburse the seller because the seller's paid this in advance and now needs to get it back. We have closing before the period is over. So we have a $300 quarterly water bill, and it's been prepaid from October 1 to December 31. Our closing is going to be on November 20th. Now, if we take the entire bill of $300 for that 90 days, that works out to $3.33 a day. From November 20th to December 31 is 41 days. So the seller should be reimbursed 41 days of a prepaid water bill at $3.33 a day, which comes to $136.67, which we credit the seller, we give the seller, and on the buyer statement, we take away from him the $136.67 by debiting him.
Some proration rules. As we've said, we're going to use the statutory method, which is every month is 30 days, and the statutory year is 360 days. The day of closing is a day of expense to the seller. The day of closing is also a day of income to the seller. For instance, if there were, let's say there were rentals that were due, the rentals for the day of closing would go to the seller. The day of closing is a day of interest expense to the buyer. So when the buyer gets his mortgage loan, he will, as of the day of closing, start paying interest on that loan. And that will do it for Chapter 23. Don't forget, in your student support site, there are some good reviews there for your exams. One is a review for the final exam. So before you take your final exam, why don't you take that? I think it's 150 multiple choice questions that will help prep you for the final exam. So that's a good way to prepare before you take your state exam. Good luck. Thank you for sitting through all these chapters with me.